Article Roman numeral 2 of the Articles of Impeachment accuses the respondent, Chief Justice, of failing to disclose to the public his statement of assets, liabilities, and net worth as required by the Constitution. I submit that the Chief Justice had justifiable and legal grounds to rely on the Supreme Court's procedural and policy guidelines governing such disclosure as embodied in a resolution promulgated way back in 1989 when the respondent was not yet a member of the Supreme Court. Under the said guidelines, the Clerk of Court of the Supreme Court, who is the repository of the SAL-Ns submitted by all the members of that High Court, may furnish copies of the SAL-Ns in his or her custody to any person upon request and upon showing that there is a legitimate reason for the same. The Constitution, in Article 11, Section 17, states that, and I quote, in the case of the President, the Vice President, the members of the Supreme Court, the constitutional commissions, and other constitutional offices, and offices of the armed forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law. RA 6713, known as the Code of Conduct and Ethical Standard for Public Officials and Employees, recognizes the public's right to information on the assets, liabilities, and net worth, financial and business interests of public servants, but it likewise declares it unlawful for any person, and I would like to quote the provision, to obtain or use the same for purposes contrary to morals or public policy, or for any commercial purpose other than by news and communications media for dissemination to the general public, close quotation, period. Whether the said guidelines violate the letter and spirit of Republic Act 6713 and the principle of public accountability is not, I repeat, is not for this court to pass upon. I grant that the Chief Justice believe in good faith that after periodically filing his sworn statement of assets, liabilities, and net worth, the guidelines issued by the Supreme Court were sufficient to allow the Clerk of Court to comply with the Constitution and the law. We cannot ignore the fact that the failure or refusal, particularly of public officials in high government positions, to provide the public or the media with copies of the SAL-Ns continues to be a raging issue to this day. In fact, some, if not most, of the members of the prosecution panel itself, the members of the Supreme Court, members of the Congress, and other high officials of the government have been challenged by media organizations and others to make their SAL-Ns available to the public and to the media. Paragraph 2.3 of Article Roman numeral number 2 further accuses the respondent Chief Justice, based on reports of not including some properties in his declaration of his assets, liabilities, and net worth in violation of the Anti-Graft and Corrupt Practices Act. The prosecution, based on the list it procured from the Land Registration Authority, claims that the Chief Justice owned and failed to fully disclose in his SAL-N 45 real estate assets. Based on the evidence, I'm convinced that the defense has presented credible evidence to refute this charge and to explain the exclusion in the respondent Chief Justice's SAL-Ns of certain properties which have either been sold or legally transferred, properties which are actually owned by his children and or third parties, and properties which were never owned by the respondent Chief Justice in the first place. I am likewise convinced that the defense has sufficiently established that there was no ill intention on the part of the respondent Chief Justice to understate or misrepresent the value of his real properties. Proceeding now to the most significant charge involving the non-disclosure of the respondent Chief Justice's cash assets. The Ombudsman, at the instance of the defense, testified with a presentation of a report from the Anti-Money Laundering Council, AMLC, showing 82 bank accounts allegedly belonging to the respondent. She further testified that based on her analysis of the report, aided by the Commission on Audit, the Chief Justice had cash assets in the examined bank accounts or of anywhere from US $10 million to US $12 million. Even if we grant the existence of these 82 accounts, the amount of deposits corresponding to each of these could not just easily, fairly, or logically be summed up to arrive at exactly how much cash assets or deposits in actuality and totality, and in totality, the respondent Chief Justice had or has at any given point of time. Hence, the Ombudsman's reference to the transactional balance of about US $12 million should not mislead this court in its appreciation of the facts. Regrettably, both the prosecution and the defense panels decided not to present the concerned bank officers or the AMLC to ascertain the veracity of the data allegedly provided by the AMLC to the Office of the Ombudsman, despite the respondent's submissions to this court of a written waiver to cause the opening of all his bank accounts. Laudable as this belated act on the part of the respondent Chief Justice may be, it would have served him better if he had just presented bank instruments, documents, as evidence to either confirm or refute the documents showing his bank transactions as presented by the Ombudsman. It has not escaped this presiding officer that initially, last May 22nd to be exact, before he walked out of this hall, of this court, the Chief Justice signed the said